Namaste, Ji, Namaste. Welcome to Courtroom. Hope you're doing well. So, the following series of lectures was part of our online program for the UPSC law optional. But since we don't teach for that specific subject anymore, I have decided to put all of those lectures from our website on YouTube. So, एक मैं पूरी playlist I'll create it, and then you can check it. You can check the links, etc., in the comments, in the iCard above, etc., and it will really help you in even in your LLM preparation, even in your judiciary preparation and law optional के लिए. So these lectures were specifically created for the law optional. They can also help you for your semester. However, if you're preparing for your LLB entrances, I say skip them because it is too much detail. You'll get confused, and stick to the basics for your LLB entrance. Alright, so I'll create I'll put this clip in front of each and every lecture that will be posted on our channel, so that you can check the playlist, etc., and it makes sense what is happening with these lectures. Alright, so it is a sequence. Try to watch them in a sequence, and hopefully you clear and get very good marks in your optional in the UPSC. Namaste. So let's carry forward our discussion. So we have already discussed on the course the relationship between the president and the council of ministers, right? So now we're going to the working of the executive president, a titular head. Now, what do you mean by a titular head? That is a person who has status but has no real power. So two kinds of questions that usually pop up in the law optional, that is president or titular head, comment or compare the provisions or the position of the president in the Indian constitution to that of the UK. Alright, so the answer pretty much remains the same. Now you'll have to include pointers from the previous lecture as well, so I'm not going to repeat myself those provisions and keep on repeating the same articles again and again and keep on repeating the same case laws. None of that is going to happen. I'm going to give you the most important bits as usual, and then basically we'll craft out an answer from that, and we'll have to revise the previous lecture as well, because that basically is talking about the relationship between the president and the council of ministers. So president titular head, now look at this provision. So article 53 clause 1 says the executive power of the union shall be vested in the president, shall be exercised by him either directly or through officers subordinate to him, that is ministers, in accordance with this constitution. Now what does this clause mean? So whenever you're writing an answer on this topic, you can pretty much quote article 53 clause 1, and in accordance with this constitution, which means basically a court can review the executive action and strike down an unconstitutional act. So limitation on president's power, number 1. And remember, we are in the broad topic of working of the executive, so we are going to take a look at all the executive members, that is still the attorney general. So who all form the executive? The president, the vice president, PM, COM, and the attorney general. That's basically part 5 chapter 1, and it says part 5 mein the union and chapter 1 the executive, and it goes from, I believe, from somewhere around the 52 article number 52 till about, I believe, 78 if I'm not mistaken. Basically covers out provisions of the attorney general. So just एक बारी बैराक खोल के please जरा उसको देख लीजिएगा कि वो कहाँ तक है. I believe that part 5 chapter 1, though I'm completely correct. Where it's ending, just note that down. Without prejudice to the generality of the foregoing provision, the supreme command of the defense forces of the union shall be vested in the president, and the exercise thereof shall be regulated by law. So that they are again have limited the president's power. So we are telling you, well, he is the supreme command of the defense forces, but again, it shall be regulated by law. So again, we have clipped the president's wings. All right. Now, prevent parliament for conferring by law functions on authorities other than the president. Again, we are taking work away from the president, conferring on other officers. So who is doing that? Parliament. It's as simple as that. So whenever we want to prove to the examiner that the president is a titular head, so he doesn't have any power. Now look at Article 74, for example. There shall be a council of ministers with the prime minister at the head. This we have already discussed. In the exercise of his functions and act in accordance with such advice. This clause was put in by the 42nd Amendment 1976. The real head, therefore, is the prime minister. Write this language down. President is more of a symbol used to formalize the decisions of the council of ministers. If you are unable to write it down while I'm speaking, then pause the video and complete the sentence. The effective executive power lies with the prime minister and council of ministers. This is the language that you must use in your answer. As in, it's not not one to one, but if you can, write some proper language such as this, I believe it will be of significant help to you in your answers. Now, K. Ananda Nambiar versus Government of Maharashtra, that's a 1966 case law. कर सकते हैं, मतलब अगर याद रह गया ठीक है, अदरवाइज तो पहले वाले जो केस लॉ जो करे हैं पिछले लेक्चर में, that should be more than sufficient. So under Article 359, an order was issued so to suspend Article 14, 20, 21 and 22. तो उस टाइम पे basically that provision wasn't there of the 44th Amendment, because 44th Amendment came in much later. So orders that 44th Amendment kaun sa wala ki 20 and 21 will not be suspended even in an emergency. So that order of basically suspending these fundamental rights was signed by the General Secretary to the Government of India. So the Supreme Court held in this case law, President's personal satisfaction is not essential for issuing such an order. So that's Article 77. So we have limited that power also. So if you want to mention this point, it's okay, but otherwise mention 53 and so use 53 and आपका 74. I believe that's good enough content for you to write in your answer. Now write this word to word. The Constituent Assembly had consciously adopted the British pattern of government. So they built in the same relationship between the Crown and ministers as is in the United Kingdom. And well, so they got the same thing in India. The king is still rather you can say the supreme formal agency in whose name action is taken in the United Kingdom. That therefore the term crown is a sum total of governmental powers and is synonymous with the executive. Same case with the president in India. He is only a nominal figurehead. Don't forget to write this, because the president is only merely a nominal figurehead. This was said by Dr. B.R. Ambedkar. So this becomes extremely crucial. So if you write it, the examiner knows that you know what you're talking about, right? And mention the point about indirect elections. If we really had to vest him with some real power, we would actually get the people for vote to him. But it's an indirect election. It's a system of proportional representation. It's not adult suffrage. So he is merely a titular head. And a key example, this is a part of history. So within a few months of the constitution coming into effect, actually something happened. Dr. Rajendra Prasad, our first president, expressed his desire to act solely on his own judgment independently of the Council of Ministers. Basically, he wanted some bit of control on assent and sending messages to the houses. Articles 86 and 111, because assent isn't given in 111. Now, Nehru then consulted Setalvad and Iyer. Setalvad, our first Attorney General, and Iyer was a member of the Constituent Assembly. They both said, no, it cannot be done. So Dr. Rajendra Prasad, didn't relent and didn't really act very crazy about it. But this basically makes the position clear, and therefore the 42nd Amendment also was brought in due to such an incident happening. There were a couple more, in fact, but let's not go there, because otherwise it will become very, very lengthy. Or वैसे भी मतलब whether you reproduce those incidents that are not part of this lecture or in your answer or not, really doesn't matter. Do mention this one. So therefore, the 42nd Amendment brought in that clause that he shall act in accordance with such advice, but it was no real change. It was just to brush aside any controversy and any further such situations from taking place, that the president wants more control. So you can also mention the pleasure of the president, not plaster of Paris, it's POP, pleasure of president point as well, that even the ministers, for example, they, technically speaking, you can say, as we have already discussed, that they are at the pleasure of the president, but he cannot just throw them out as per his whim or fancy, because they, as long as they enjoy the support of the majority, or rather the confidence of the majority in the Lok Sabha, the president, really, his power is limited. And therefore that sums up the answer on president is a titular head or president has no real power. This question can take a multitude and mutate into a multitude forms. The answer remains the same, connected with the previous lecture, and I believe that you'll have a top class answer at your hand. Now, Prime Minister Sir Ivor Jennings was the foremost constitutional law expert back in the day. So he said, the Prime Minister is the keystone of the Constitution, and all roads in the Constitution lead to the Prime Minister. This in fact is asked in even LLB entrances. All roads in the Constitution lead to dash. MHCD वगैरह वाले पूछते हैं. But anyway, law optional के अंदर Sir Ivor Jennings. तो अगर याद रह जाए तो please quote it in your answer. Makes the answer look good. Now he is, now let me just go through quickly क्योंकि actually हम प्राइम मिनिस्टर के बारे में काफी बात कर भी चुके हैं. So he is the leader of the majority party, the head of the council of ministers. He coordinates government policies. He is the link between the president and council of ministers. He, technically speaking, appoints the ministers, because without his wish, the president, how will he appoint the council of ministers? He can ask president to remove. We have already discussed this, how the prime minister can actually invoke presidential powers of the president and get a minister to resign if he so wants to, but usually the minister resigns himself or herself. So he's the principal spokesperson of the cabinet. If he resigns, all ministers automatically resign. This is also called the concept of collective responsibility. We are just coming to that. But this person, whoever is the prime minister, has to always enjoy the confidence of the majority of Lok Sabha, and majority rather in the Lok Sabha. He has to have support from colleagues and other party organs. Just because you are the PM once doesn't mean that you leave everyone behind and can do anything as per your own whim and fancy. Because if you don't have support from your colleagues and other party organs, how exactly are you expected to enjoy the support of the majority in the Lok Sabha? Alright, so he's also called the primus inter pares, Primus, inter, INTER, pares, PARES. Okay. Note this crucial point down. When VP Singh took the oath of Prime Minister, Devi Lal took the oath of Deputy Prime Minister, and Deputy Prime Minister is nowhere given in the Constitution. It's not a constitutional post. So there was a case law, KM Sharma versus Devi Lal, where the Supreme Court said no problem if the oath is basically, the substantive part of the oath is correct, the descriptive part has a problem that he took oath as a deputy PM. So the oath doesn't become invalid as long as the substantive part is alright, descriptive part is okay. They said really doesn't matter. So Devi Lal was the deputy PM. Now when it comes to cabinet, now cabinet is nowhere mentioned in the Constitution of India. So the nucleus of the Council of Ministers is the cabinet, and the Council of Ministers comprises of the cabinet, the Minister of States, the deputy ministers. But the cabinet is really the effective policy making organ. So if you actually go to part 5 chapter 1, you're not going to find the word cabinet in the bare act of the Constitution. All you have is the Council of Ministers. So cabinet is basically, it's a conventional body. What do you mean by conventional? So these are UK conventions which are not hard coded into the Constitution, but we still follow them. So therefore the cabinet is there. Now, okay, as I've already mentioned, there is no reference to the cabinet in the Constitution. So it's a conventional, it's an extra constitutional body. Write that down. Cabinet decides the major questions of policy and is binding on other ministers. This is the convention. So anything the cabinet decides, it is binding on the other ministers, because the Council of Ministers is a really, really large body, and they pretty much, never ever really wholly meet. But the cabinet does meet, and whatever the cabinet does, the other ministers have to follow. So usually in the coalition governments, usually whatever the cabinet does, the other ministers says, well, to hell with you. Okay. So this is the case. Now, ministers in the routine matters, sure enough, you can take decisions on your own. But in matters of significant policy and political implications, the matters which are going to have political implications, that is, the cabinet is the sine qua non body to go to. All right, so that is cabinet. Now we come to the principle of collective responsibility. Herein, let's see this. The Council of Ministers shall be collectively responsible to the House of People. And mind you, Council of Ministers is made up of a lot of ministers. So they fall together, they stand together. It is just like a team. All right. And duties of Prime Ministers respect the furnishing of information to the President. If the President so requires, to submit for the consideration of Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the council. So the president can tell PM, well, get this matter reconsidered by the Council of Ministers. So all ministers stand or fall together. They have to have the support of the majority. In Lok Sabha, they are all responsible to each other, but on top of it, they are collectively responsible to the members of the Lok Sabha, or majority of the members of the Lok Sabha. So even if there may be differences of opinions, the ministers still have to act as one. You cannot criticize. Basically, one minister cannot be criticizing the work of any other minister in public. They cannot disown such work because it's one body. So therefore, they are collectively responsible to the House of the People. All right. Now, if you, let us say, have a dispute, you can choose to resign. So one individual minister may choose to resign. Effective decision-making body is obviously the cabinet, but the Council of Ministers has to support them fully. All right. Now, that doesn't mean that, like, for example, let us say that one minister say, no, but I never really participated in this policy. For example, right now, some minister can go up and say, I'm against the farm laws. The government has made a huge blunder by enacting these farm laws. Well, you resign. You cannot say this in public. Even if you really never participated. So, for example, that minister also says, no, I never participated in such a decision making process. They never really consulted me. So, I am out of this. One minister cannot say so. You'll have to fully back the cabinet. The Council of Ministers has to fully back it. Even if you haven't really participated in that particular decision, you still have to fully back it up. So they have an individual responsibility. The president shall make rules for more convenient transaction of the business of the government of India and for the allocation among ministers of the said business. What does this mean? So there are officers under these ministers जो इनके लिए काम करते हैं, they can't, so they are liable under vicarious liability. They cannot disown those officers. So your IAS, आपके जो आप basically जो जहाँ पे जाना चाह रहे हैं, you'll be working in these ministries. And therein, if the minister, let us say that, so you also have a significant amount of power. There are some decisions that only you will take because आप उसमें ज़्यादा domain level expert हैं, the minister is not. And the minister, so if you are under the department of the minister and if the minister you take such an action, then the minister has to own up to it. So the minister will be speaking about it in the Lok Sabha if basically he or she is questioned on the work that is done by you. So, but because you cannot go to the house as a public servant, as an IAS officer, or as whatever of whatever cadre, you cannot go to Lok Sabha and Rajya Sabha to represent yourself. So who is going to represent you? The minister under whom you have worked and the work that you have done, because every day-to-day administrative tasks the minister will not be doing, you only will be doing. All right. So therefore the ministers themselves take many decisions without reference to the cabinet, except for the ones that are impacting policy and politics. And there are officers in the department who work and they are not referring to the minister. But agar kuch gadbad hui, the minister has to own up. So he is individually responsible for his own department and he is collectively responsible as a team, or rather a team member of the Council of Ministers to the House of the People. All right. So he's still personally responsible. He answers to the House, and mind you, let us say that he's being attacked, he will be defended by, not shall, but usually is defended by other ministers as well. Parliament, and for a minister, if the minister weren't answerable, then Parliament will not be able to exercises its role. Basically, the Parliament's one of the chief roles of Parliament is also to be a critic of the executive, because if they are not sitting there, the executive will do pretty much anything, and then all hell can break loose basically. So working on the executive, we've worked out the president, a titular head, the prime minister, what is the cabinet doing, how are ministers collectively responsible, how are ministers individually responsible. I believe in one more lecture we are going to completely finish off this topic. A majority of it is done. Maybe you can say 90% of it's done. 10% ancillary details are there relating to the Attorney General and a couple more powers of the executive. Now, ordinance making power we have already discussed. We started out this topic from that lecture. So ordinance making power I'm not going to discuss. Other powers of the executive I'm going to discuss, and the provisions relating to the Attorney General. And I believe this topic will be crystal clear and will be prepared in a very, very good manner. All right, now see you in the next lecture. Take care.